Welcome back to Empire Law. I'm Kara, and today here we have Deborah Song from Empire Law. Deborah, how are you doing today?
I am doing okay. Thank you for having me.
I love that. Good to have you on. So today we are talking about what happens after a car accident in Inland Empire. This region spans two counties, SB County and Riverside County, with some of the heaviest truck and commuter traffic in South California running through it on I-10 and I-15. We are going to cover everything from what you do at the scene to how California's fault-based insurance system and the filing deadlines dealing with insurance companies and when you actually need a lawyer. If you have been in a crash anywhere in the IE, this episode is for you. What should someone do immediately after a car accident in the Inland Empire to protect their claim?
Well, first things first, ensure safety. Make sure everybody is safe to get out of the car. If the scene is already safe, let's say there's no traffic hazard where you can get out of the car immediately and leave everything as is without moving the vehicles to the side. It's always nice to be able to get out of the car as is and then take pictures and videos of the vehicles exactly as they came to rest after the accident. And then you can move the vehicles to the side, if that's okay. If it's a dangerous situation and there's cars moving around, then go ahead and pull over. Then you can take the videos and photos afterwards. But if possible, always collect the photos and videos of how the vehicles came to rest after the accident. Then call the police. Even if you're not feeling hurt at the moment, state that you are injured. Because if you say you don't have any injuries, the police may not come out. And then you may lose a chance to file an official police report. And if you don't have a dash cam, which a lot of our clients and first-time accident goers don't have, you may lose the chance, and the other side will now have an opportunity to dispute how the accident happened and come up with a new story that they later on state to the police, not the police, the insurance companies. And if you don't have a dash cam, another thing you can do when you get out of the vehicle and you go to communicate with the other driver is pull out your phone very obviously and turn on the video and start recording that person and any verbal interactions that you have. Sometimes I have seen the other side explain what happened, and a lot of times that will help with the liability dispute, especially in like a lane change situation where they may later claim that you changed into their lane, and if not vice versa, you will obviously say that they changed into your lane. But if you have that video communication, that helps a lot. And when you are recording them, just make sure that you make it clear that you are recording, because California is a two-party consent state. And then after that, after documenting everything and you moved over to the safe location, you exchange information. When I say exchange information, I'm talking about a photocopy of their registration, their driver's license, take a picture of their license plate. Oh, another one is, even if it's a rear ender and they just rear-ended you, take a photo of the back of their car. A lot of times I see they tell the insurance companies later that somebody rear-ended them and pushed them into you. And a lot of the times our clients, they don't have pictures of the back of their car because they don't have a reason to take pictures of it. But if you have a picture of the back showing that there are no damages, then it becomes harder for the other side to continue to try to prove that up. If there's any witnesses, even if they're about to leave, collect their witness information, collect their contact information. That becomes helpful later. I know you're probably frazzled and it's really hard to think about all of these. If you can just like write this stuff down and like just put it in your glove compartment so you can whip it out and use it like a little checkbox to make sure you have all, that would be good.
Yeah,
And then
absolutely.
if you are in pain, and you can't afford urgent care or something like that, then contact us and we can help you find somebody who can treat you on a personal injury lien basis. But use your insurance or pay out of pocket if possible first.
Yeah, definitely. So before even calling any law enforcement to document everything with your video phone of the damages and what happened, and then after that's all collected and everyone's safe, then that's when they can call the law enforcement.
At times, if you call the law enforcement first and they show up, they won't allow you to take pictures.
Yeah.
And they will do all the talking with the other side. And then they will take pictures, which is weird because when we order the police report, it never comes with pictures. So I don't know what happens to those pictures.
Mhm.
Maybe it's just for their own memory for when they write the report. It's like their own little internal memos that they do for themselves to remind themselves when they're drafting the report. But whatever pictures they take, it's not in the police report. So make sure to take any photos, talk to the other side if you can before the police comes out. And then when the police comes out, let the police do whatever they need to do.
That's great to know. Most people do not realize that there is a separate state reporting required beyond the police report. So, are you legally required to report a car accident in the state of California? And what happens if you miss the deadline on that SR1 form?
Yes, and just like you said, it's called an SR1 form. It's spelled like S as in Sam, R as in Robert, and the number 1. You can type it in on Google, just DMV, California DMV SR1. And usually like the first top link, there's actually a link where you can fill out everything out online. It used to be all manual and paper mailing, but now you can do it online. And you have to fill that out within 10 days. If number 1, there's any injuries, number 2, there's any deaths, or number 3, if there's any property damage that's over $1,000, regardless of who's at fault. If there is an accident and there's injuries or damages to your car that's more than $1,000, you need to report it to the DMV within 10 days. And if you're not sure what the damages are and you're not sure if you're injured, it's always better to play on the safe side and just file it. And this is different from the police report. And if you don't file it within the 10 days, it can result in a license suspension.
Wow. That's good to know. So within 10 days, correct, to fill out the form, and they can do that at the convenience of just going online and filling it out there.
Yes. And
Okay.
if they need help, their attorney should be able to help them with that as well.
Beautiful. The Inland Empire covers a massive geographic area, and the hospital you end up at can depend on which part of the region you crash in. So, where should someone in the Inland Empire go to get medical care after a crash, even if they feel fine?
Yeah, so after a car accident, you may feel fine due to an adrenaline rush. So it may take time for your adrenaline to settle down. But sometimes symptoms, they don't appear right away. They often appear later. And I hear this from clients all the time. It usually will appear when they get home after the accident, when they're getting ready for bed and they're lying in bed. When they're in that resting state, that's when usually the pain kicks in. And if not, it's the morning after. So the next day they'll wake up and it'll feel like they got hit by a truck. And even if you wake up the next day and you're not feeling any symptoms, still go to any nearby urgent care. If you're having concussive symptoms, and that might be something that you might talk to an attorney with to find out if you are, you should go to an ER. But I do understand going to an ER, an emergency room, it's an all-day thing. So if you're not trying to do that for the full day, I would say start at the urgent care. If you do end up having concussive symptoms, though, they will stop seeing you. So even after you wait at the urgent care and then you go and you tell them what you're feeling, they will say, hey, you need to go to the ER and go get CT scans because the urgent cares don't have it. So let's say, I would say whatever is your health insurance, if they take that health insurance, go there. It doesn't matter where it is. If you don't have health insurance, wherever the closest one is, the cheapest possible, the urgent care, go there. If you don't have health insurance, there's and you go to an ER, depending on your financial situation, you can actually apply for emergency Medi-Cal, which is a California government-funded health insurance program, and it gives you temporary health insurance that the government pays for at the time. But that kind of depends on your financial situations and your assets. If you already qualify, I guess you wouldn't know at the time, but you could apply and see if it works. And if you're not sure, always the better thing to do is just call us or call an attorney and see what your options are. And worst case scenario, you don't have any of those options and urgent care and hospitals are too expensive. We have urgent cares that can treat you and see you on a personal injury lien basis. But for sure, even if you're not feeling symptomatic the next day, still go, because prompt documentation is crucial, not only for your health, but your claim. So if you're not symptomatic, just go and say, hey, I just got into a car accident. I just want to get checked out and make sure I'm okay.
Yes. So be seen as soon as possible, even if you're not feeling anything at the time. The IE draws people from all over the country. And if you come from a no-fault state, the rules there are fundamentally different. So how does California's fault-based insurance system actually work when it comes to a car accident claim?
Okay, so California uses a fault-based system, meaning the at-fault driver and their insurance is responsible for your damages. So you can file a claim with the at-fault party's insurer, but you can also use your own coverage for certain benefits, depending on what's available under your own policy. Because sometimes, even if the at-fault party has accepted liability and their insurance company said they are willing to pay, there are situations where they simply don't have enough in their policy to pay for everything that's required for you and your car. Yeah.
Good to know. Very good to know. Most drivers do not realize how low the minimum coverage actually is. So, what are California's minimum auto insurance requirements, and why do they matter if you are the one filing a claim?
As of now, California's minimum auto insurance requirements is $30,000 per person and $60,000 per accident for bodily injury. And then for property damage, it's $15,000 for all the cars involved, if not including the at-fault driver. So this would include any other vehicles involved. If it was like a 2, 3, 4 car pile up, it would be $15,000 shared amongst all the cars. But these limits matter because they set the amount for the minimum coverage that the drivers are required and they must carry. But a lot of times these damages that our clients sustain, they exceed those amounts. And if your case and the damages that you sustained are higher than these minimums, then you have to pursue additional compensation. And this additional compensation either comes from the other driver's personal or commercial assets, and that would be done through a lawsuit, or you can go through your own underinsured motorist coverages as well. And that's what I was talking about earlier when we were talking about the at-fault based insurance system, is sometimes, a lot of times, you end up having a lot more problems and issues, and your case may be worth a lot more than what the other person has. And a lot of times in the Inland Empire, a lot of people are driving around with the minimum coverage. So they're driving around with 30,000, they're driving around with 15,000. They're causing a lot of big accidents, and then cars these days, even the repairs are worth more than 15,000. So it's very important that you have coverage on your own insurance policy to cover yourself in situations where the other side either doesn't have insurance at all or doesn't have enough.
Yeah, absolutely. This is one of those rules that can completely change the outcome of a claim. How does California's pure comparative negligence rule affect what you can recover?
You can recover damages even if you were mostly at fault. So your recovery is reduced by percentage of fault. For example, if you are 70% at fault, you can still recover 30% of your damages. So there's situations where, let's say we had a client, he was on a motorcycle, was mostly at fault, but in my head, I'm thinking, is there even a 1% chance of arguing that there is some comparative to the other driver? Is there anything that I can pinpoint and find that they could have done to prevent this accident from happening in the first place? And I did. So there's only 1% that we can recover. But even with that 1%, the client, because it was a motorcycle accident, had huge injuries, ended up having to be hospitalized, multiple fractures. So we were still able to collect on the other side's insurance company, collect the full policy limits that was available. And that's I think that's one of the good things about, I think, California, is that even if you are mostly at fault, if there is some sort of argument an attorney can make that the other side is partially, even 1% at fault, it can help with the compensation.
Okay. Someone has been in an accident. They have documented everything. They have been to the doctor. So now what? So walk me through just the step-by-step process of filing a car accident insurance claim in California, and who should you contact first?
If you are going to file a claim against any insurance company, I highly recommend you talk to an attorney first. If you can hire an attorney and let them do all the talking and opening up the claim for you, it's always best, because even if what you're saying doesn't sound like anything bad, the other side and the insurance company, they'll always figure out a way to twist your words. And so it's always best to have an attorney to even open up the claim. But let's say, for example, you have to, I'm not sure. I can't imagine a situation where you wouldn't hire an attorney first, but let's say you have to. So you would call the other side's insurance company and you would say, hey, I was involved in an accident. I need to file a claim. Can you help me? And so they will start to gather and collect information from you. If at that moment you are unsure if you're at fault or not, or there's some sort of questioning as to who's at fault, or you are anticipating the other side is going to spin the story in some way, the less talking, the better. So if you can file the claim, a lot of these insurance carriers, they actually have a way to file claims online. And so if you can just limit it to that and use less words as much as possible and go through that process, that's always the best. But if there is no option for you to file it online and you do have to call in, still try to keep your answers as short as possible. If you can limit it to one sentence each. And if you're not sure, just say, I'm not sure. The whole point is just to get the claim open. Just say, I'm not sure, move on, I'm not sure, because they're just trained to go through the list. There may be certain things like the date of the accident and the time of the accident where they can't just skip through. So those kinds of information you should give. But if there's any question and you're not too sure, just say you're not sure. You'll figure it out. You'll call them back. You'll let them know later. And then just move on. And then same thing with your own insurance company. You should open up a claim. And I know a lot of times clients, they don't want to open up a claim with their own insurance company. They're worried that their premiums are going to go up, and they think to themselves, why do I have to open up a claim with my insurance company? I'm not at fault. But if you are claiming for injuries, there is a law in California called Proposition 213, and it requires all Californians to have auto insurance coverage. And the only way the other insurance company can verify that is not through you, but through that insurance company. So if you have your own insurance company, you have to open up the claim so that the other side can verify you do have insurance. Because if they cannot verify you do have insurance and you are injured, you are going to be categorized under what's called the Proposition 213, and you will be limited in what you can recover. So any kind of pain and suffering, any kind of general damages, which usually makes up a huge portion of the claim, is excluded from being able to get compensated. Then after you open up the claim, an adjuster will be assigned. And there's usually a property damage adjuster first. Also, they may ask when you're opening up the claim, they may ask if you're hurt. If you're not hurt at the time or you're not symptomatic at the time, don't say no or don't say I'm okay. They may even phrase it as how are you feeling to make it sound like it has nothing to do with the claim and it make it sound like they're just concerned. Don't say I'm fine, just say I'm not sure if you're not symptomatic. If you are symptomatic, then tell them what your symptoms are. And then after they do that, they'll assign an adjuster. It may take a couple days. That adjuster is maybe either a property damage adjuster or what's called a bodily injury adjuster. So there may be one or the other. The property damage adjuster is assigned to handle the repairs on your vehicle. If your car is a totaled car, they will handle the compensation to pay out on your totaled car. And then there's the bodily injury adjuster that's assigned if you do claim that you are injured, and they will handle the bodily injury portion of the claim.
Wow, that's really good to know. But overall, less information, we tell them, we just say that we're not sure, or less is more in these kind of situations.
Yes.
So most people assume it is just the car repair and the medical bills, but what type of damages can someone recover in an Inland Empire car accident claim?
There are two legal words that I would say we would use. It's either economic damages and non-economic damages. There are two. There's technically a third one called punitive. That's more so if it's an intentional tort, if it's a hit and run, if it's a DUI, driving under the influence, that kind of situation. Those are a little bit more rare, but that is a third option as well, of punitive damages. But if we're talking about strictly compensatory damages of making you whole, then there's economic damages you can think of as something that's economical, something that can be calculated based on economics. So medical bills, those are clear bills with numbers on them that say you owe XYZ. This is how much the health insurance paid. Then you have lost wages, which is also economic. It can be calculated based off of multiplying the time you had off of work, showing your pay stubs to show what you were making before the accident compared to when you were missing time off of work. And then you can just subtract the differences and get compensation for that leftover amount. Even if you've utilized sick pay, PTO, holiday pay, a lot of times our clients do that. Let's say they ran out of sick pay and they had to call time off. They would use their holiday pay or things like that. So technically they don't have a lost wage in the sense that they still got paid. But the way we look at it is now you've lost your chance to use that holiday pay or PTO, paid time off, or sick pay for another time that was unrelated to the accident. Now it's being depleted. So we do want to get that back. And then property damage. Any repairs that need to be made to your car, those are estimates made by appraisers, made by inspectors. There's a number on there. And if you have to get into a rental, there's bills from Enterprise or Hertz or whatever rental company you end up going with. So whatever number's on there, that's an economic damage. And then there's actually one that we specialize in that I don't think any other firms in California does, which is diminution in value. So this is a claim for even if your car is repaired, now you have a ding on your car for when you try to sell your car, there is an accident record. And if your car has an accident recorded on it, that alone, even if they fixed your car immaculately and it was just a fender bender, that information alone lowers the value of your car. So when you try to go to CarMax or wherever else to sell your car, now you can't get offered what you would have been offered prior to. So we do get compensation for that. We hire an expert to find out how much your case would have been worth without the accident and how much your case is worth now because of the accident. And we ask for that difference. So those are the economic damages. Then you have the non-economic damages, and these are things that cannot be calculated economically. These are things that don't have necessarily a bill attached to it. So these would be things like pain, suffering, the general damages I was talking about earlier. If you're under that Proposition 213 that you're excluded from receiving, this is, I think, a pretty big portion of your claim. And it's the pain, the suffering, emotional distress. Those are like the common words people use, but it's more of how this accident has affected your day-to-day. And when we do send out our settlement proposal letters later, we do incorporate all of that. We are going to talk to you first and make sure we capture everything and how your lifestyle has changed. Even if your injury is not bad, you will be shocked to see how much you've adjusted yourself. Like, you think to yourself, oh, I'm not in pain anymore. But a lot of times it's because you've changed the way you do things to make sure you're not feeling those symptoms, to make sure you're not using that muscle, to make sure you're not triggering those symptoms. So those kinds of things, you can't really put a dollar amount. Like, how much is it worth when you have pain brushing your teeth for 2 minutes? Or how much is it worth if you have trouble bending over the sink for 30 minutes washing the dishes? Things like that. So those are things that we take into consideration, and while we're working on your case to figure out, okay, how much is this case going to be worth? But that is something that you can also get compensation for. And then that last one, the punitive damages, that's to punish the other driver for doing something intentionally, whether intentionally fleeing the scene, hit and run, whether it's drinking and driving under the influence. Those are usually the common ones. I've had a case where the Uber driver kicked the passengers out and said, you got to go after the car accident. I think it's because the clients were saying that the driver seemed to be smoking marijuana because there was a smell of marijuana from the car. And I think they were worried. So they kicked him out of the car and they left him there. So that could be another version of punitive damages as well.
Wow, that's great to know. So I know we already touched on the adjusters, but this is going to be a repeat, so you don't have to go super detailed into it, but just a short answer would be good. So most people assume that adjuster is on their side. What should you say or not say to an insurance adjuster after an Inland Empire car accident? And should you ever give them a recorded statement?
If you must speak to an adjuster, like I said before, I don't see why, if you have an attorney, I really don't think it's a good idea. But if you must, just be factual, just be concise. If you can answer with yes, no, just say yes, no, don't add on anything else. If they want more information, they will ask you, and answer in one sentence. Don't minimize your injuries. I know a lot of people, they don't want to sound like they're being complainers or they're whining, but don't minimize it, because that only helps them. And it'll diminish the value of your case and how much you can recover later if you try to add things on at a later point. And of course, do not give a recorded statement without consulting an attorney first. If for some reason you choose to do it anyway, and they ask you if you're hurt and you don't think you are, just say you're not sure, because you never know down the line if later on you realize, you know what, yeah, I'm seeing this bruise develop, but you never talked about a bruise, you never talked about hitting anything in your car. Just say you're not sure. What else? Sometimes clients, they're not sure when the statement is a recorded statement, because a lot of times they'll just say, oh, this call's being recorded, monitored for training purposes, whatever. But it's not that. The recorded statement is very obvious. It's very formal. They'll start a recording and it'll be clear, because they'll click a button and they'll say, today is April 16, 2026. And they'll say at 12 o'clock p.m., I am talking to your name here, and this is the recorded statement. So it'll be very formal, and then they'll start going off on the Q&A. So if you're hearing that, you can hang up. There's no obligation. If you don't realize that you're being recorded until later, you can just hang up. That's fine.
But they will formally let you know if they
Yes.
are doing a recorded statement. Okay,
Yes,
so
and
they're
it's gonna be
obligated
very
to do that.
obvious.
Perfect. Beyond the adjuster call, insurance companies have a whole playbook. So, what are the most common tactics California insurance companies use to reduce or deny claims?
Even if you are not at fault, if, and this is why having an attorney is important, if you've said anything or if they've had an opportunity to talk to their own insured and there was no police report, there's no dash cam, there's no video recording of anybody saying anything, if there is any way that the insurance company can convince their own insured to confuse them and as to how it happened themselves, because sometimes the other driver, they're very forthcoming and truthful, and then the insurance company will come in, will be like, are you really sure that's how it's happened? And then they get confused and they're like, you know what, I'm not sure. So at that point, they'll just go ahead and dispute liability, and any way that they can put percentage of fault on you, they will. And then that, of course, reduces the value of your claim. So let's say your case is worth $1,000. If they put 50% on you, now your case is, you can only recover $500. So that's $500 just thrown out the window. Delaying settlements, they like to do this a lot. So once you send a settlement proposal letter, by law, they're entitled to up to 30 days to review everything. We like to give them 32 days just so that if we are trying to open up the policy, and that's something else, but if we try to do that, then we can by giving them ample time. So they're entitled to 30 days. And a lot of times, if you don't follow up with them even before that 30 days to make sure they have everything, they will claim on that 30-day mark, they will call you and be like, hey, I can't give you a response because I am missing this bill when it was all there. A lot of times what happens is when you send off your settlement proposal letter along with your medical bills and your medical reports, lost wage pay stubs, pictures of your injuries, whatever it may be, it gets separated. When you email them, it gets sorted into like different departments. And then the billing department will sort the bills, the medical records department will sort through the medical records, and everything else will get sorted in different departments. And then afterwards, they will draft up like little memos or little reports, give it to the adjuster and say, hey, this is how much we think the case is worth. And then the adjuster does what the adjuster will. So sometimes it's true. Sometimes it's true that somehow the bill got lost during that whole process. But if you follow up with them a week after the demand, or a week after the settlement proposal letter was sent out, just to confirm, hey, did you get it? Did you receive everything? Are you missing anything? Put it in writing. And if they say, no, I have everything, then you know that you won't have to give them extra time to give you an offer. So a lot of times they like to delay their settlements. Gap in treatment is a huge one that they utilize to not only reduce the value of your case, but also deny your claim entirely. And that's why I was talking about earlier, if you can go to the urgent care or somewhere the next day, even if you don't have any symptoms, just to get yourself checked up, it's always better to do that. So you have a documentation that you had treatment pretty soon after the accident, because let's say your symptoms don't come up until a week later. If you go like a week later, now the adjuster's going to be like, maybe you just slept wrong. Maybe you just went to the gym. Maybe you were just carrying something. They start making stuff up, like, because a lot of anything could happen within that week is their argument. So if you can go and get that documented right away, and then the doctors, usually if you go to urgent care, they'll just say, oh, take some pain pills, or, oh, you'll be fine. If you do have symptoms, it'll go away in a few weeks or whatever it may be. If they do say, usually they'll also say follow up with your primary doctor. Make sure to follow the instructions and make your appointments and do everything.
Yeah, absolutely. The IE freeways are heavily monitored with cameras, and the truck traffic generates its own documentation. So, what evidence behind photos and medical records can make or break a car accident claim in the Inland Empire?
There are a lot of cameras on California roads in general, whether it be the freeway or the local roads. Those cameras are usually live footage. Those are usually not something that's being recorded at the time. It's usually utilized for police chase when they want to follow some kind of car somewhere to make sure that they don't lose them. So even though that the camera is there, it's not capturing anything. But and I think you asked about the freeway, so this wouldn't matter. But if it's on like an intersection on a local road, a lot of times these corner stores or even Ring doorbells in a residential community, it will capture the accident. A lot of times the bigger stores, they won't really cooperate. You may have to just be very nice and tell them the situation. You may even have to pay them to get that footage, because they have no obligation to do so unless they're a good Samaritan, they'll volunteer it. But if you're going to capture that, you have to do it within, I always say safely within 7 days, because those recordings, they automatically loop over. They're like stored in like their hard drive, or they're stored in the cloud, and then they only have a certain limit before they start deleting and saving the new footage. So make sure you do that within the first 7 days. And if you can't, the best thing to do is, if you at least have the address, is send over what's called a preservation letter, and it'll basically notify them, put them on notice that you have to save this footage. We'll deal with it later, we'll grab it later, whatever it may be, but at least save it right now, put it aside. We may need it for litigation purposes later. It's a letter that says something like that. So if the defendant, if they have any kind of footage, dash cam footage, if they choose to delete their footage even after receiving that notice, now we can actually utilize that against them in court and said that they caused a spoliation of evidence. They have deliberately chose to erase the evidence, and the jury can do what they want with it, with that information. If you were involved in an accident with a commercial vehicle, a lot of these vehicles have dash cam built into their trucks, and the reasoning is because usually the commercial carriers, they will incentivize the owners and the companies to put the dash cam in and install it in the vehicles, because if they do, their premiums will be lowered, because it saves the insurance companies in situations where the truck isn't at fault. Because when we're talking about commercial trucks, usually those policies are like $1 million. So if they can save money and not pay out on a claim, they will do. So most of those trucks, they have a dash cam footage. So it's very critical that you go on to the Secretary of State, and this is something that your attorney can do, of course, but you can go on the Secretary of State, California Secretary of State website, whatever the name is on the registration or the insurance card, that company name, you look that up in the Secretary of State website, and it'll show, if you find that entity, it'll show, if you click on it on the right-hand side, it'll show what's called the agent for process of service. And to send that preservation letter, you have to send it to that particular address, to that particular person or entity that's designated. You can't just give it to anybody at any, let's say, for example, it was a Costco truck. You can't just go to your local Costco and give them that letter. You have to give it to whoever has been legally designated to accept legal documents on behalf of that company. So you can do that. Those are very helpful. Witness statements are always, of course, helpful. Police reports can be helpful. Sometimes repair estimates can be helpful. And this is why I was saying, like, if it's not too dangerous and if you can get out of the car right away and take pictures and videos of exactly how the car was located and positioned after the accident happened, sometimes, depending on how big your case is, the attorney will hire what's called an accident reconstructionist. And that person, based on those photos and videos, can determine how the accident happened in a situation where liability is being disputed. There's quite a few things that are pretty helpful when it comes to evidence in your claim, other than just your medical records and photos.
Yeah, that's great to know. You mentioned the documentation trail earlier, so let's dive into that. How do medical records and documentations affect a car accident settlement in California? And what is medical lien?
So, medical documentation, like I was saying earlier, it's pretty important when it comes to your case value. So a lot of times you can say how you're feeling to an insurance adjuster, and you can tell them how you're feeling as far as the pains you're experiencing, how it's affecting your day-to-day. But if it's not documented by a medical doctor or a healthcare provider, then they won't just take your word for it. It's not as strong of an evidence as a third-party neutral would be that's documenting your symptoms and what you're saying, giving you a treatment diagnosis, and giving you a treatment plan as well. So those are important. If for some reason you don't have health insurance, you cannot afford an urgent care visit, it's typically like a little less than $200. But if you can't afford that and you don't have health insurance, you don't think you'll qualify for emergency Medi-Cal, then we have another option. And usually this is done with an attorney, and it's called a personal injury lien. It's a medical lien. And you can think about it as care credit. I don't know if you are familiar with that. You go to these clinics and sometimes you can't pay for their services. So they'll allow you, I think vets have them a lot too, where you can't pay for your upfront payment of surgery for your pet and things. But it's like a credit card, right? And you open it up and then they can pay the providers, and then you just pay the credit card company back on a monthly basis or whatever until your payments are fulfilled. It's a similar concept. So it's basically a piece of paper, and it's an agreement between you, the doctor, and the attorney. And the reason why the attorney is important when it comes to these medical liens is because they're usually not going to run your credit, because they're doing an IOU based off the end of a case. So the doctor is taking a risk of not taking upfront payment from you, not taking your health insurance that you don't have or that they don't accept, and not having you apply for care credit or things of that nature. They're basically saying, okay, it's like a deferred payment plan. You can pay me after your case is closed. But they usually want an attorney involved because it gives them a little bit of assurance that if an attorney has taken on the case, then it's a case that's most likely going to result in their bills being paid back in full. And they usually won't do that just between you and the doctor, because they don't have that kind of confidence in you to be able to execute your own claim and get all the compensation you need to fulfill the doctor's bills. But that's usually what that agreement is. Everybody signs, and after the case is over, then your payment becomes due. And sometimes that means if that case didn't settle well and it didn't pan out to recover any kind of compensation, you are still liable for that debt, because it's still services that the doctors have provided you. But that's why it's important to talk to an attorney and make sure that it's okay and that it's a good idea, and that I think the medical liens and the personal injury liens, those are like a last resort, but it is very helpful when you're trying to do instant documentation. It's like a PPO health insurance type of plan. It's something where you don't need to worry about Medi-Cal taking five months to approve a PT visit or something like that. It's very immediate, and the doctors can do and execute all the treatment that they need on you and refer you out to whoever you need to be seen right away to get the treatment you need to get recovered very quickly. So it is a pretty powerful tool.
Yeah,
but yeah, it is
sounds very efficient, but also you want to be careful of what you do so early on. And like you said, just consult with an attorney first to see if that's the best move long term, especially as well. How long do you have to file a car accident lawsuit in California, and what happens if you miss it?
Generally, you have 2 years from the date of the accident to file a lawsuit. If you miss the deadline, you lose your right to sue. And if you lose your right to sue, even if you were in the middle of, let's say, negotiating your case and you were right around the time of settling and you're going back and forth a little bit, they have zero obligations to pay you anymore. So sometimes there's situations where we have clients that are still treating and they're around that 2-year mark, and we haven't even talked about negotiating the case because we don't know the value of the case because the client is still treating. We will file suit just for the purposes of preserving that 2 years, and then we can continue on with whatever we were doing. But even if you're in the middle of whatever, if you don't have money in your hands within that 2 years, you better file the lawsuit, and then you can deal with whatever's happening during that time. But if you don't, then you lose everything. Whatever you were doing, it's gone.
There are expectations for that 2-year standard, and one of them catches a lot of people off guard. So are there situations in California where the deadline gets extended or shortened for some reason?
Yes. So claims against government entities like Caltrans or a city have a 6-month deadline. It's a 6-month deadline not to file the lawsuit, but a 6-month deadline to file a claim with that city entity. And a lot of times these get a little complicated because within a city, let's say you have a case against public bus transportation, and you are in, let's say, our city here in the city of Norco, you would have to figure out who owns the bus, which city is it, because usually these city buses, they go everywhere, right? And then you got Riverside Transit Authority, the RTA, then you have the county of Riverside, you have the city of Norco, but if it's the Riverside Transit Authority, maybe it's the city of Riverside. Then you have the Department of Transportation of California. So you have to make sure that even if you're not sure, just file it all with all the claims, with all the entities, potential entities within that 6 months. Because if you mail that letter and filing the claim with those entities, they have 45 days to respond to you. And if they realize you didn't send the letter to the right entity, they may wait up until that last 45 days to send you a letter back being like, hey, you filed the claim in the wrong place, and now you just blew your statute because you filed it at the last minute, and then now you have no time to file it anywhere else. So you have 6 minutes for government claims. If you successfully file that, then the city or whatever entity, government entity you filed with successfully, they have 45 days from when you have mail or when they've received the letter from you. I always send it with tracking just to make sure, and then I'll calculate it 45 days from that time. Then you have, after that 45 days, sometimes the city will deny it. They have 45 days to deny the claim. And if they're nice, they will send you a letter saying denied. And then you have 45 days from that day, or 6 months from that day, the day that they have officially denied your claim, to file a lawsuit. Or you'll have 6 months from the 45-day expiration date from when they've received your mail or when you've mailed it out. Then you have 6 months from that date. Depending on whatever comes first, you have 6 months then to file the lawsuit. So with government entities, it's shortened, extremely shortened, and you have to do it quickly. With minors, it's extended. So when you are under 18 years old, usually your parents, your guardian, your mom or dad will be the one to file the claim for you, to negotiate for you, to settle the case for you. Now, legally speaking, because you are a minor, even if you're 17 and a half, if you are a minor, you cannot enter into a contract. So your parents will sign on your behalf. But if your parents aren't involved, and if your injuries are pretty big, because you are not legally capable of entering into a contract, the law allows you to have until 2 days from the day you turn 18. So the day you turn 20 years old will be the last day that you can file a lawsuit on whatever accident you had and whatever injuries you sustained from that accident when you were under 18 years old.
Wow, that's really good to know. So, how is fault determined in a car accident claim in Inland Empire, and how much weight does the police report carry?
So fault is determined by evidence, and that will include things like police reports, witness statements, physical evidence in the sense that if you took any pictures or videos from right at the how the accident ended up and in the positionings of the cars and how they were positioned when the accident finished. And then sometimes expert analysis, like I said, the accident reconstructionists, they will be the ones to take all that information and say, you know what, I think this is how the accident happened. There's the so you have San Bernardino County and you have Riverside County. It it'll impact which agencies investigate and which courts will handle the case if the case goes into litigation. If it's San Bernardino County, more likely than not, the police isn't going to come out. And I think it's just the crime rate that's over there in San Bernardino County. It's just very high. So a lot of times they won't show up. So if it's very important that you're hurt, even if it is like you have to call the ambulance, be like, can you send the paramedics? Sometimes that helps, calling the police out, and they'll come and do the police report. Riverside, I think, is a lot better when it comes to that, but you still most of the time need to say that you're injured, otherwise they won't come out. So that might impact the way the accident is investigated. The police report itself is legally what's considered hearsay evidence. So it's not admissible when it comes to court. If you were going to go to trial, we cannot submit the police report and let the jury have at it and read it. You would have to bring in the police officer, and the police officer would then state what they remember about the accident and what they put in their report and things of that nature. But even if the police report is not admissible, it's still very helpful as long as you're not put at fault. It's very helpful when it comes to trying to dispute whatever the other side is saying. So it prevents the other side from trying to deny your claim because they're saying the accident happened another way. So whatever it says on the police report, they utilize that as gold. I have seen some situations where the insurance companies, they even with the police report, they're like, yeah, no, your client's at fault. In a situation like that, it happens, it's rare, but you just file suit and you file a lawsuit, and then you just move on to the litigation process and get the compensation you need that way.
Yeah. Can you still file a claim if you were partially at fault for the accident in California?
Yes, under the pure comparative negligence, which is what we have here in California, it's called pure comparative negligence, you can recover damages reduced by your percentage of fault.
What happens if the other driver does not have insurance or flees the scene in Inland Empire?
If you are a victim of a hit and run, immediately call the police and file a report within 24 hours of the incident. Many insurance companies, including Mercury, require a police report to be filed within 24 hours to provide what's called uninsured motorist coverage. But if you do, and if you're not sure, the best thing to do is just file the police report and we'll worry about whatever coverages you have later. But if you do have what's called uninsured motorist coverage, which is coverage that's rendered to you in a situation specifically like a hit and run, or where the other side, even if they didn't hit and run, if they just don't have insurance, they're just driving around with no insurance. Let's say they forgot to pay their bill that month, and so they have no coverage that month. It protects you in that situation, and your own insurance company will pay out on your claim. And then after they paid out on your claim, they will go after the other party and they will get their money back afterwards. So it's very important to file that police report within 24 hours. I've had a situation where the client didn't do that. It still was okay because we still demanded arbitration and we still won the arbitration because we also even if that's the situation, the insurance company has the burden of proof that they have been prejudiced in some way. The design of that policy that they put in there is because they don't want insurance fraud. They don't want people going around like pretending to get into accidents and saying they got into an accident just to get a payout when there is no accident that happened, or they made it themselves. They backed up into their own wall of their own house or something. So if you call the police, they feel like it's less likely a lie. That's their logic. So call the police, make a report, and then after you make a report, you contact your insurance company. Hopefully you have an attorney and you don't have to contact your insurance company, but if you don't, contact your insurance company and provide them with the police report number. And then if you need medical care, you probably should get an attorney to help you with that if you can't go through your own health insurance and you can't go through out of pocket.
Yeah, definitely. And then what makes Inland Empire car accidents different from other regions, and how do those local factors affect claims?
Like San Bernardino County, for example, a lot of times the police, they don't come out. And even if they do come out and they make a report, that report takes a very long time to be produced by the department because they're so busy dealing with other things too. So if you aren't in an accident and you're just watching this and you're trying to get information for just in case in the future, the best thing to do is have a dash cam. You can get it on Amazon. It's so cheap. And make sure that it comes with an SD card. If it doesn't come with an SD card, that means there's no point in just having a dash cam up there. It's recording nothing. It's like the live footage cameras that are on the freeways and the roads. It's just a video camera that's recording nothing. So make sure there's an SD card plugged in there. Plug that in, and then you can be more rest assured when you're driving around. Riverside, I don't think there's too much of a problem with Riverside. I think when it comes to the two jurisdictions and how it may affect the claims would be more so on our end that we're worrying about, let's say, the demographics of the jury or the type of judges that are going to be sitting on your case. So depending on, it's like a lottery. So if you file the lawsuit, you get assigned a judge. And depending on that judge, even though the judges are supposed to be neutral magistrates, there's things that we know about some judges and they have these like internal biases that they shouldn't have. And so depending on who that judge is, and when we go to our hearings, we can get a kind of a good idea of where they stand. And depending on that situation, I will make that determination and be like, you know what, this is a case we need to settle, or this is a case that I think we might win at trial, and it'll change the trajectory of the case and which direction to go.
Yeah, absolutely. And then a lot of people are not sure if their case is big enough to justify calling a lawyer. When should someone seriously consider hiring a car accident attorney in the Inland Empire?
I think you should seriously consider hiring an attorney before talking to any insurance company. But even if it's a situation where it's not a case that the attorney wants, or it doesn't fit their criteria of their firm, of what they're looking for whatever reason, it's a free consultation. So at least you'll get legal advice as far as moving forward. If it's a case they want, they'll tell you like, hey, let's sign up. But if it's not, they'll be like, hey, we won't be able to help you. Some other attorney can. And if they won't, make sure when you're saying this to the insurance company, you say it like XYZ, or they may advise you like, hey, when you file the claim, just do it online through their website. So you're not actually talking to a live agent who can trick you on the spot. And then usually what I'll do is sometimes I'll just have them, hey, as you're going through the prompts, usually they'll do it on their phone. As you're going through the prompts, send a screenshot to me to make sure that I can see it and you're putting all the right information in. And when you're submitting it, so that you don't say anything in that prompt to hurt your case. So yeah, I would say anytime before talking to an insurance company, you should consider at least talking to an attorney, hiring if possible, and especially before opening up the claim. It's nice to have the attorneys do it for you so you don't have to worry about saying anything that might hurt your case. And attorneys are always designed to maximize your recovery, because the more they can get for you, the more they're getting for themselves as well. So it's a win-win situation. Then attorneys are always helpful, especially when we're talking about government claims and I think just in general, just talk about it and you will hear, based off the attorney's knowledge, how complicated the case is. If it sounds complicated to you, then you probably would want to hire somebody. But if it sounds pretty easy, then maybe you might choose, you know what, maybe I'll try to handle it by myself. And usually the attorney will, if they're honest, usually they'll be like, hey, you might not need our help for this. You might be able to do it on your own, rather than try to take you on and charge you a fee just for the sake of it.
Yeah, definitely. And then this kind of goes hand in hand, but what are the most common mistakes that seriously hurt a car accident claim in California?
Number one, not seeking prompt medical care. Number two, missing deadlines like filing the SR1 or the government claim in time. Number three, giving recorded statements to insurance companies, telling them you're at fault, even though you might think you didn't say you're at fault. If you say it in a way where it sounds like they can cut and paste and say you said you were at fault, or failing. Number four is failing to document evidence. That's also very hurtful for your case. If you delay medical care because you can't afford it, you risk weakening your claim as well. Because even though you're going through it, if there isn't a third party to document that for you in your medical records, it allows the insurance companies and give them an out and start poking holes in your claim to say something else could have happened during that time. Always try to use your health insurance or pay out of pocket first. If you cannot, and let's say that delaying it's going to cause a delay in medical care, definitely talk to an attorney. Make sure they can find you a doctor who can treat on a personal injury lien basis. Or if you already have a doctor that you like, you can ask them as well, hey, do you do cases on a personal injury lien? And even in situations like that, the attorneys may want to vet them out, because if later on your case is a case that needs to go to trial or a lawsuit needs to be filed and that doctor needs to testify, we need to make sure that they're not going to get cold feet and back out at the last minute and not testify. So we want to make sure that if you are choosing a doctor, that we would want to interview them and make sure that they're going to be there for you when it counts. Let's see. Number 5 would be
Anything regarding social media and posting after an
yes,
accident?
sure. When it comes to social media, try not to post. If you are somebody who likes to post, then just private your account. If there's anybody who's trying to follow you or friend request you and you don't recognize who they are, there's a very good chance that it could be the other side. Don't add them. Don't let them follow you. Because when you go to litigation, it doesn't really affect it so much beforehand, but when it goes to litigation, after your deposition, they usually will hire a private investigator to start following you around, because during that deposition, you may have testified that you can't do something. And it's something that we talk to our clients about before their deposition too. But you may testify that you cannot do something anymore because of the accident. The moment you say that, they will hire somebody to follow you around to catch you doing that exact thing you just said you couldn't do. And then they'll bring that in court and they'll show it to everybody after you tell the jury, like, I cannot do this anymore. And they're like, oh, really? And they'll show it up. And then they'll also have the private investigator dig through your social media. But if your social media is privated, they can't really dig through that. So that's also important. You don't add anybody you don't recognize. I would say that's probably something that would also hurt your case. Yes,
That's
social
huge.
media.
Yeah, no, definitely. Deborah, this has been incredibly valuable for someone listening right now who has been in a car accident in the Inland Empire, whether that is in SB County or Riverside County. What is the one thing you want them to remember?
Call a lawyer. It doesn't hurt. The worst thing that could happen is they said they don't want your case and then give you free legal advice on how to move forward. It's always best to do that. I think that's always the best thing to do.
If someone wants to talk to you about their car accident claim, what is the best way for them to reach Empire Law?
They can call us at 951-456-3891, or they can email us at info@empireatty, that's like attorney, A as in Adam, T as in Tom, T as in Tom, Y as in yellow.com. So info@empireatty.com. Or I think there's options to go on the website as well, or they can text us through the Google My Business page.
And that first consultation, that is free.
Yes.
Okay, good to know. If you have been in a car accident in Inland Empire and you are not sure what to do next, make that call. You can find Empire Law at www.empireatty.com. That's EMPIREATTY.com, or call them directly at 951-456-3891. Thanks for watching, and we will see you on the next episode of Empire Law.